then whether that partial, allowance goes in your favor or not, right? So please avoid that mistake. It is very grave mistake. You will lose a lot of marks in your memorial and in your oral arguments also. It will cost you the whole round if judge will catch you. All right. After that, there comes written submissions, how to draft it, how to write it. The trick is very simple. You have to follow IRAC process. I will do one thing. I will share my best memorials with the faculty of your institution, and they will definitely share it with you. All right. So whatever I will tell you right now, you can see in that particular, memorial and mood problem. So I will give you mood problem at the same time memorial. Whenever we take reference from any memorial that is best, okay, best awarded memorial, you should never read it, you know in bare sense, because if you will read the memorial, you would not come to you will not be in a position to understand what was the contention of all those parties. All right, so before reading any memorial, what you should do, you should read the mood problem first of that particular competition, and then after reading that problem, you should read the memorial. Then only you would be able to analyze the right position of both the sides as far as their arguments and written submissions are concerned. All right, so read the mood problem, read their memorial, and you would come to know about the fact that how IRAC method is followed in any competition, in any memorial. If you have rightly followed IRAC methodology, you would be in top 5 memorials. That's for sure. That's for sure. First, you have to tell the factual issue, and then you have to give a brief background as to on what all grounds you will be, supporting your arguments. And after that, you will deal with different sub issues, and the matter will be solved very easily. All right, and after that, there comes very important part, that is formatting of memorial. I must say that formatting is something that is very tedious and tricky job. All right, and you should be very well equipped with the skill of formatting, and you should have very good command over Word, MS Word, for that matter. See, uh, there are different softwares for different kinds of profession. Okay, all those people who are very good in marketing and MBA and business management, they are very good in making PPTs. This is what I have observed through my limited experience. All those people who are very good in accounts, they are very good in handling MS Excel. But at the same time, all those people who want to be a very good lawyer, all right, in their career, they should have very good command over how to handle MS Word. You should know different shortcuts, because generally what happens, the formatting part is done at the last 2 days of the memorial submission, and it is very much difficult for everybody to draft the memorial because it is very difficult. And if formatting is not proper, you will end up losing 20-30 marks for sure. Let me tell you, you would consider yourself that you are very good in MS Word. However, let me tell you, when we check memorial, I personally believe that I have not given more than 3 to 4 marks out of 20 as far as formatting is concerned, because I find a lot of error in formatting and footnoting. Now this is very much important, because you cannot just simply present your memorial, and all these exercises are being done to prepare you for the real world practice. All right, you cannot just simply write anything, put anything anywhere, and then submit before the court. Let me tell you honestly, if you will submit any petition before Supreme Court of India, your petition would be rejected on many irregularities that you would commit. So we need to avoid that, and this is the reason why mooting, drafting memorial, formatting it helps you a lot. in beautifying your document. And if your document is beautiful, definitely you are going to get 20 out of 20 marks in that. Okay, so formatting is something which you should always take care of. You should always continuously format your memorial. Generally teams, what they do, they write and they draft their memorial. They put a lot of thing, but they think that we will do the formatting part in the last 2 days of the competition, and by that time will be gone. Let me tell you honestly, because if you are in habit of formatting every day and footnoting, making proper footnotes every day, things would be very easy for you. It's simple. It's like classroom program. Whatever your teacher is teaching today, you should you should revise it today itself. You should make your notes. Only then you would be able to match up the level. All right, if you will think that you will read everything in last 2 days of the examination and you would top your examinations, that's a very wrong notion that you are carrying, if at all you have that kinds of notion. So you should always format it. You should always draft a memorial regularly, and you should make sure that everything's are at right place. All right, so I've already told you.
Sir,
Yes, Aditi.
sir, should we put cases according to the citation?
Cases according to the citation. I do not understand your question.
Sir, I'm asking that if we are preparing a memorial, then that we should put cases in memorial according to citation.
Of course, you should. Of course, because see, the title of the case has no relevancy if there is no citation, right? You would find that many cases has different kinds of citations. All right, so you should always keep that thing in mind. So what you should do, suppose if in the body of your argument you are stating that in the case of Menaka Gandhi versus Union of India, the honorable apex the honorable apex court has held that, whatever line is there, that you are quoting, you should use control alt plus F. Okay, footnote. After in footnote, you can mention Menka Gandhi versus Union of India, comma, and the citation, and close it with full stop. All right. So you should always give citation to the case that you are referring to. Otherwise, it will have no relevance. All right.
Yes,
For
sir. And sir,
instance, yes,
if we are mooting at that time, sir, we should put facts also of a case, or
like
we
at
should
the
read
time of oral
only
arguments.
judgment. Yes, sir.
See, of course, see, at the time of oral arguments, you can definitely say that, my lords, in the case of X versus Y, the Honorable Court has held this. And in the present case, also, the situation is very similar. So, if at all the judge would have any kind of problem with respect to the same, he can ask you that, counsel, please tell me the facts of that case. All right. So, definitely, you should know about all the facts, because suppose if you are referring to 120 cases in your memorial, there might be a situation that you would not know each and every facts of all those cases. However, all those cases that you are citing while oral argumentation, you should always know the facts of that case, and not only facts of the case, what was the observation of the court, what was the judgment and order of the court, and after that, who were the judges and in which year the judgment has been given. Because there are situations wherein judge may ask that, who was the judge in this case, counsel. So you need to answer that. There are I remember I was in finals of Surana and Surana, and the judge had asked me about a case law, that who was the judge in this present matter. All right, so I told him that there were three judges, wherein honorable justice so and so has given the judgment. All right, so there is a difference, we should understand. So there may be three judges, five judges, all right, but there is one judge who puts his signature, who delivers the judgment, all right, who writes the judgment, and everybody has their contribution in that judgment also. At the same time, there is only one judge who signs the judgment at the top of it. So you should always take name of that particular judge. It is very much important, and it will have a classic remark and a classic um, what do you say, impact, positive impact in the mind of judge. Let's see, the council is even aware about who were the judges and who was the presiding judge in that particular case, and it will fetch you a lot of point, and definitely you will win that particular round. So you should know about what you are speaking, because it is very much important. If you are not aware as to what you are speaking, you will lose your case for sure, and you cannot afford to do that after spending 4 to 5 months rigorously in your moot court competitions. All right, so I have a question. Is it necessary to follow complete case judgment along with contentions and facts before mentioning the said case in moot memorial? Of course, Rashmi, you should do that. You should do that, because suppose if you will not, everybody knows about control F, right? You will research a case, you will get the judgment, you will do control F, you will search for that particular word, you might find 2 to 3 lines in favor of your argument, but there may be a situation that all those contentions that you are relying on are have been dismissed by the court. So in such situation, you should always check upon whether the lines that you are referring to is the contention of counsel or it is the observation of the court. If at all it is the contention of the counsel, then you should always check whether it has been very well appreciated by court or not, or whether it has been upheld by the court or not. So you should always do that. Always do that. All right. So these things you should always keep in mind while drafting your memorial and while submitting it. And after that, once you are done with your submission, you should always prepare yourself and do one more thing in your life. Please follow this. Change your mood problem after 10 days. Understood? Shall I elaborate on this? Suppose you have 2 copies of mood problem, one from the side of applicant, the other from the side of respondent. All right. What happens? You have your notes in those documents, and you should always, on alternate days, you should read your mood problem. If you are not master of your facts, you are not going to win your case. All right. So what you should do in that particular situation? You should always change your mood problem after 10 days, and you should read it again and again make your points. You will come to know about the fact that, of course, you would get different points after reading and changing your mood problems. You would, suppose you get 7 points from first reading in first days. If you will change your mood problem, you will get another. You will read it. You may find 1 to 2 extra points. All right. And as far as my personal experience is concerned, let me tell you, I was in a competition, and in the morning itself, I was in semi-final, and I was again reading my mood problem, and there was one question जिसका हमारे पास answer नहीं था, and whatever answer we were doing, whatever answer we were giving, the judges were not getting convinced. So I was reading, the fact sheet again and again, and in the morning I came to know about a fact that we can use this particular fact, okay, like this way, in different way. And in semi-final, we used it, and the judge really appreciated it because he was judging rounds since prelims. All right, and he said that he acknowledged that point. And after the rounds were over, he said that whatever interpretation you brought with respect to that fact is very good. I really liked it. So of course, you should always read your mood problem again and again, so as to get different kinds of interpretation. You never know what kinds of interpretation you may get. All right, after reading that problem. So this is all with respect to all these things. And I have already told you what research methodology you should follow. Always you should go for statute first, like what the law says about it, the codified law. After that, you should go for authoritative commentaries. Go for books, read, because in commentaries there are different compilation of cases, and it is simplified, and whatever commentaries cases it contains, everything is the judgment of the court and not the contention of the counsel. All right. So suppose if you find any judgment in your favor, you can then definitely go to that particular judgment, open it, read it, analyze it, and then cite it in your memorial. and you can also research on all, online legal research database such as, Manupatra. Over there you will get different articles also, apart from judgments. Hein Online, ResearchGate, all these things are very much important. All right. So these things you should always keep in mind. And yeah, so I have already told you about what all things needs to be followed in writing the memorials. So I will deal with each and every pages. All right. And I will let you know what all, typical things that every student misses, while making any memorial. So let's come to cover page. Can anyone please tell me what all things a student must keep as far as cover page is concerned? Anyone would volunteer? Anybody?
Sir, may
All
you
those people.
please repeat?
Aditi, can you please tell me what all things we should keep in the cover page of memorial?
So, name of the parties and
All right.
jurisdiction, name of the court, and
Good.
on which party memorandum has been filed.
Very good. So what we do, we at the top of the, cover page, we write the name of the competition. After that, we write the name of the forum before which we are there. Let's say before Supreme Court of India. Then we write about the jurisdiction, under which article we have approached the Honorable Supreme Court or High Court for that matter, or any other, adjudicating, you know body. No Pradyuman participant's name is not allowed. If you'll write participant's name, you will be disqualified from the competition, because in order to maintain anonymity, the organizers definitely ask the participants not to disclose any identification with respect to their university, college, or their name. All right. So these things are avoidable. If you will refer to the rules of the competition, you will come to know about this fact. All right. So after that, jurisdiction part, we write the name of the parties. you know just below the name of the parties, we write what are they appellants, are they respondents. So can anyone please tell me in which situation we write appellant, in which situation we write petitioner, in which situation we write claimant? All right, can anyone please tell me? Or for that matter, in which situation we write applicant as the first party? Can anyone please tell me? No?
Sir, if
Yes,
we are talking about appellant, then when we are not satisfied with the judgment of a lower court, then we appeal in the higher court.
all right.
I think there
So in
will
that
be
situation,
appellant, and
all right,
and and sir, if we are not sir, I'm not sure, but if we are filing an application to a court, then we will be applicant.
all right,
And sir, if we are talking about petitioner, then we file suit in family cases and constitutional cases, and we will be petitioner.
all
Like
right.
special leave
Aditi,
petition we are filing, then we are petitioner.
all right. Aditi, let me tell you, you are absolutely current on this point. I have seen a lot of people making mistakes with respect to the same. Generally, what happens if your mood problem says that the party is directly moving before the Supreme Court through writ petition. In that matter, we would write the first party as a petitioner. Suppose if your fact sheet tells that High Court has passed the judgment and the first party is aggrieved by the judgment of the High Court, in that situation it will be appellant, because he is assailing the he is assailing the order of the High Court through an appeal. And after that, if suppose if any matter is still going on, and any bail application or any XYZ application for that matter, the first party files, in such situation the first party would be applicant. So Aditi, you are absolutely correct that in such situation the name of the parties are like this only. So we see a lot of errors with respect to the same. We encounter such errors. That is why I felt that I should tell you all that always you should be very clear as to whether you are applicant, claimant, petitioner in the case. All right. After that, table of contents are there. In the table of contents, you should always write the contents of the memorial, including your issues, sub issues, from which page number it is being started, at which page it is ending, and it should be very beautifully arranged. I will share my memorial. You all can take reference from that. After that, there comes index of authorities. So index of authorities, in this we write different books that we have referred, uh, case laws. It is always advisable to bifurcate your case laws because it looks very nice. Okay. When you bifurcate, or you call out Supreme Court cases in one table, and after that high courts cases, and after that research articles you can cite, lexicons, all these things you can cite as far as index of authorities are concerned. Moreover, please follow this thing that whatever books and whatever judgments that you have mentioned in your memorial that are there in the index of authorities, if any of the case laws that you have mentioned in the index of authorities is not present in the footnote, you will lose a lot of marks for that, and it will have very negative impact on the mindset of the evaluator. Moreover, what happens, you read 15 cases, sorry, you read 15 books for a moot court competition, but you have cited only 3 of them in your memorial. So you should always write only 3 of them and not the 15 of the books. Nobody is really concerned about how many books you have read. People are concerned about how many books you have referred as authority in your memorial. All right. After that, there comes statement of jurisdiction, which is very important. And you should always be very clear as to whether the court has jurisdiction or not. And if you are challenging the jurisdiction, you should always write it in your statement of jurisdiction in very humble language. Now, the key point over here is this, that all those people who have done moot, let me tell you, whatever statement of jurisdiction you write for the first party, you copy and paste it in the second party also. Is that right or not? Whatever jurisdiction the first party writes, you copy it and paste it in the respondent side also. Is that correct? Anybody? Or you write different thing? See, suppose
Same
if
thing,
I
sir.
am, same thing, right? If I approach any court, all right, and the court is having jurisdiction under article, let's say 32 of Indian Constitution. So petitioner will write that the petitioner has approached this honorable court under article 32 of Indian Constitution, which says this, all right? And even respondent says that yes, the court has jurisdiction under article 32. But the language of the jurisdiction has to be different. It should be tweaked a bit in favor of the respondent, like this: the petitioners has approached this honorable court under article 32, which says this, to which the respondents are making submissions through its written memorandum, or to which the respondents are replying or responding to the contentions of petitioners through this written memorandum or written submissions. All right. So you should always write this. These are several things that will fetch you marks, and it will have positive impact in the mind of evaluator. All right. Now quickly coming to the part, I guess I'm taking a lot of time in telling you all these things, but I feel that all these things are very much important for you all to to consider while mooting. So now coming to the statement of relevant facts. Generally what happens, always people are not sure as to what all facts are relevant. All right. And they present facts in very argumentative manner. All right. So you should never follow it. You should always present facts in very balanced manner. All right. The facts should not be in argumentation. You should never mention facts which seems like you are arguing anything. So you have to simply present your facts, and it is always advisable to write facts in one pages, only in one pages, because it is very simple. Even at the time of oral arguments, if anybody would say that please state the facts, you would waste your 2 to 3 minutes time stating facts by saying that XYZ is a country, and it is a democratic country having population of 1.5 billion people. All these facts are irrelevant facts. The relevant fact is this, that there is a law, all right, and there is a person. The person was saying all these things by criticizing the government, and the government has put a ban on his account by passing this notification. Aggrieved by such act, the XYZ person has approached this honorable court under article so and so of the constitution. Now the matter is before this honorable court for final adjudication. That's it. इतना ही होता है relevant fact. इससे ज्यादा कुछ नहीं. We are not favoring petitioner, we are not favoring respondent. We are presenting only balanced, undisputed facts. Undisputed facts means both the parties have no concern with respect to the same. Neither of the parties is denying the existence of that particular fact. So we should always go for it. Always present your facts in just one pages. Now coming to the summary of arguments. Summary of arguments is nothing but the gist of the argument advanced. But you should always follow one thing, that you should give rationale behind your summary of arguments rather than writing down specific sub-issues. What we do, we say that the right of Mr. So-and-so is not violative because of, if you have 4 sub-issues, you write it down. No, it is not like that. You should never do that. You should give analysis in just 5 to 6 lines that why his right is getting violated. All right. So in summary of arguments, you will not write the mere language of the sub-issues. You will write the analysis and conclusion of that particular arguments. All right. And after that, argument advanced comes. So in argument advanced, I have already told you that you have to follow IRAC methodology, and then wherein you will analyze the issue, rule, analysis and conclusion. And after that, you should always, sum up your arguments. Do not forget to close your issues by making formal, request for submission. That means you should always close your issue by stating that this is the main issue and it is in our favor. All right. And after that, the most important part comes, that is prayer. We argue our case, but we do not know what we are seeking from the court. All right. We say that, pass a judgment that the said notification is in violation to the rights of the person, right? If you'll write that, please declare that because of the ban of the state government, his right is getting violated. Fine, we'll declare that. Will it serve any purpose? You should always think as to what you want. You should always write, declare that the impugned notification passed by the government is arbitrary and in violation of the right of the petitioner, and pass an order to lift that particular ban. That is the main, prayer that you are seeking. Just mere declaration of anything would not serve your purpose. You want order in your favor, right? You should always write it. Okay. And if at all you are able to figure out as to what writ should be issued in your favor, write that, please issue the writ of mandamus or quo warranto, or, any other writ for that matter, and things would be solved. Okay. So these things you should always keep in your mind, and please be sure that, drafting memorial and writing anything in the memorial is not as simple as it looks. Okay. Seeing and analyzing different kinds of memorial is different thing, and drafting it is a very different thing. So you should always keep these things in your mind. So I'm done with all the points that I wanted to cover for my lecture, and now the floor is open for you all to ask questions. I would really appreciate if you will ask a lot of questions.
Sir,
Yes.
uh, if I filed a petition in High Court, and then uh, High Court gave judgment in favor of another party, then if I am
Yes.
filing special leave petition in Supreme Court, if I'm not wrong, I will be petitioner in this case. I'm
Yeah.
filing special leave petition.
Yes, it
Okay,
is
sir.
a special
Thank
leave
you, sir.
petition. For that matter, you will be the petitioner in that matter. All right.
Thank you, sir.
Any other issue? Any other issue which you all face while drafting your memorial? Anything you can ask. Anything from Oscola, Blue Book, ILI, these kinds of formatting styles. You can ask any questions. I would be really happy to answer that. No questions? If you do not have any questions, so there are two situations. Either I was boring you all, I was not clear, or I was very clear. So nothing can be very clear for that matter, let me tell you. Okay, because when I was a student, things were going, over my head when my teachers used to teach, because I was very notorious one. So what is that? You do not have any questions?
The participant ask any question, so you can ask.
Anybody? All right. So I'll consider that my session was very good. I guess I have, sir, this is new to us, but we learned a lot of things. All right, but thank you so much. I look forward to give many more sessions like this.
Thank you so much, Advocate Shubham Mishra ji, for being with us and joining us in such a short notice. Moreover, I find I do not know why participants are not responding, but I could see a few participants. They were very interactive. They had queries and very well addressed. And I am sure,
Ma'am,
and faculty is very much sure that you very ably satisfied our expectations and took the session in a very, very interesting manner, and all the participants are benefited and enriched. Thank you so much, Shubham. And surely we will invite you once again and again for more such vibrant sessions. Thank you so much.
Thank you so much, ma'am. It was an honor.
मानसी कुछ पूछना चाहते थे आप?
Yeah, somebody was asking a question. I guess.
Yes, sorry.
no, sir, I was saying that there is a network issue also.
Okay.
Was I not clear at the time of session?
No, you were
Sir,
clear.
I left in between. You were very clear. You were very clear. Sir, I left in between, then I rejoined, so things are not that much clear to me.
Okay. I hope the recording will be available.
Don't worry, there is recording and every participant will be shared.
Yeah. So
Thank you.
Pradyuman, of course, I will share my memorial. Rajesh ma'am, I will share my three memorials. One is the best memorial of international law. The second one is the best memorial for national level moot court competition, and there is another best memorial for trial advocacy competition. So I'll share everything. All right. So please just note down the name of that competition and read the moot problem, and then after that please read the memorials. It will be helpful for you all. Thank you so much.
Thank you so much. Thank you.
Thank you, sir.
Thank you so much.
Now, sir has given a speech with the depth level and taught us everything about the voting is very important and drafting is very much important. Have the habit of drafting and the practicing. And types of the moot court competition, 3 types should go for the trial advocacy competition. The structure of the moot exercise gave experience also the structure of the research for the Moot time. We are very thankful, sir. Now I request to the Professor C.S. Raghuraman from Hyderabad. Please, sir, over to you, sir.
Thank you, sir. I am Mr. Raghuraman, Professor of Law from Hyderabad. I really enjoyed this session, like I enjoyed the morning session. Mr. Subham has delivered a comprehensive and exhaustive lecture on preparation of memorials. I just wanted to add two things, or perhaps three, because of my experience in many moot court competitions, which I personally conducted as a coordinator in the presence of sitting judges of the Supreme Court way back, 20 years back. 5 judges in one moot court and another 3 judges, sitting judges, were invited for 4 or 5 moot court competitions. And some of the teams have lost the preliminary rounds, even though they were expected to reach the quarterfinals and semifinals and perhaps finals, because they have missed 2 points. One is the judges, they have made them to answer questions about the dissenting opinion of any citations. Sometimes you know that the majority opinion is the law of the land, but sometimes the dissenting voice of a single judge minority, they wanted to know what is the opinion of the participant mooters, whether they will argue that this dissenting opinion must be given importance. And also about arbiter of the earlier citations, also we have to read what is the arbiter, why it was declared as an arbiter, not a ratio. And I have seen many cases where the arbiter was elevated into a ratio after 5 years or 10 years gap in the same high court or in the in Supreme Court. Because sometimes the dissenting opinion of a judge or arbiter will be a ratio in future. So that is also one thing. And another point I want to make and suggest is, if one of the participants is having some minus points while giving training, and in the moot court real competitions in the semi-finals or preliminary rounds, the other student, he must try to cover those issues as far as possible, so that they will be presenting the arguments in a precise and in a beautiful manner. I have seen some times one of the students is very good and the other student is not so good as the first mooter. So we suggested them, you have to help him. After he presented his arguments, you have to give some more information on those same arguments with the permission of the judges who are sitting on the bench. That is also one point which I come across in many competitions. And finally, I have to suggest that the opposite parties, that is, if you are appearing for appellant, you should also anticipate what are the counter arguments of your opponent teams. You must visualize. You may not have 100%, you may not be sure from which side or which point they will attack your arguments, or they will cite contrary decisions with your decision. Suppose I am quoting a decision from the Supreme Court, High Court, there may be naturally there may be contrary decisions in favor of other sides. Those contrary decisions also we should collect, and we will have a research then, so that we will present an argument where we cannot give any scope to the opponent to attack our arguments, our issues. So that's why this is also very important, because in one moot court where our college students have bagged the winner prize with a cash prize of 25,000 in those days, I'm talking. And one of the participants, he has presented the contrary judgments also to the judges as a fair dealing, and it was appreciated by the judges. So only the judgments which are in your favor, but also you should also fairly accept and agree and cite, sir, these are the contrary judgments, but I request you to ignore the contrary judgments and take the favorable judgments to give us more marks or more successful to be in the competition. This is also very important. So I am very, very happy that the two lectures which are given by two eminent personalities really helped, and I want the students to note down and seriously follow the suggestions given by all these people, because you should always keep in mind knowledge is not a monopoly of a single individual. If you think that your opponent is more intelligent, more resourceful, and you have to prepare with that in mind. You may be very competent, you may have so many cases or so many knowledge, so many favorable points, but you should always think that your opponent is more intelligent, more resourceful, and have more citations than what you have. So this is my advice, because I have been a judge of many moot courts, and also I was training the students of many institutions for the last 20-25 years of my teaching experience. So this is my observations for today's training program. Thank you very much. I'm very happy to be associated with the university. Very, very happy for today. Thank you, sir. Thank you.
Thank you, sir. Now I request to the chairperson, Dr. Rajesh Sudha. It's over to you, ma'am.
Can we feel making this noise or disturbing?
No.
Okay. Okay, Dheeraj, just conclude and announce the tomorrow's plan.
Okay, ma'am. Thank you all the participants, and also especially thank to the Advocate Subham Mishra and the Professor Raghu Raman, because without their experience and their knowledge, this program cannot be successful. And I also thankful to Department of Law, BPS Kanpur, and the faculty members and all the participants who participated in the moot court. And after these sessions, feedback form will be sent to you in chat box, and you have to fill this feedback form. It is mandatory to all of you. Otherwise, the certificate will not be issued to all of you. Now, Tomorrow program is at 11 a.m. You all the participants join timely before 10 minutes to start the program. And thank you to all of you. Now I'm sending the feedback form in the chat box. You have to fill. It is mandatory to all of you.
Oh,
Those who are
Dheeraj,
participating.
Dheeraj, I would make a correction. That feedback form I will share in the valedictory session tomorrow only, and feedback of all the 4 technical sessions is compiled in one feedback form. So all participants are supposed to make out and be available in the valedictory session mandatorily, and then after we will collect your feedbacks.
Okay, ma'am. Okay.
Okay, see you tomorrow. Till then,
Thank you.
jot down all the important points and enjoy. Thank you, Dheeraj. Thank you, Professor Raghu. Thank you, Dr. Annu. Thank you, everyone. Thank you.
Thank you, ma'am. Thank you all of you.
Thank you, ma'am.
Thank you, madam.
खत्म हो गया क्या? ना ना, मैं दोनों चला रहे थे ना इकट्ठे, उनका भी क्या है। कल उनका ना है अपना अपना 10 बजे होगा। 10 बजे आप बाबू से फोन कर दिए 10 मिनट पहले। हाँ